the introductions and the biomaterial is there for everybody. And individual athletes eligibility, who can't play and why, with specific emphasis on golf. We're really lucky enough, Lisa, to do the specific introductions. They have Eve Wright with us from the LPGA, and Chris Callanan, who represents individual athletes in the and also in the Olympic context. So tennis, golf, Olympics is next after NFL, NBA, and then baseball will be after lunch. So we're covering all the sports today. And as I said, Lisa's introduction, her biomaterial is here, and I was lucky enough to work with her many years over at the IMG Legal Department. So with that, Lisa, I'll let you take over the panel and welcome our guests. Thank you very much.
Thanks, Peter. Well, as Peter mentioned, we've been hearing today about some eligibility issues affecting participation for athletes in team sports, namely football, basketball, and this afternoon we're going to be hearing more about baseball. This next panel is going to focus on eligibility issues affecting individual sports athletes, sports like golf, action sports, skiing, and extreme sports. To take us through these issues, we've got two other panelists. We've got Eve Wright and Chris Callanan. Eve Wright is the Senior Director of Legal Affairs at the Ladies Professional Golf Association, which is a nonprofit corporation which promotes women's golf. Through her position, Eve is involved in several facets of the organization, including corporate governance, LPGA tournament contracts, sponsorships, licensing, retail merchandising licensing, and all legal matters related to the LPGA.com. She's also involved in trademark issues and foreign trademark prosecution and television broadcast initiatives. Ms. Wright also provides legal advice regarding advertising campaigns, sweepstakes, and other LPGA promotions. Eve is a graduate of DePaul University, where she received a bachelor's degree in economics. She got her JD from Indiana University School of Law, and she's participated in the consortium program at Howard University School of Law. And to Eve's right, we've got Christopher Callanan. Chris is a shareholder in the law firm at Campbell, Edwards, and Conroy in its Boston office, where his practice is devoted to litigation and sports law matters. He graduated from the College of the Holy Cross and from Boston College Law School. Chris represents Olympic, action sport, and professional athletes with a focus on marketing and endorsement endeavors. He's represented Olympic athletes in hockey, skeleton, snowboarding, and judo, and has assisted with the marketing of professional golfers, tennis players, football players, and hockey players. So we're very happy to have these two panelists here with us today. The structure of our panel is going to be a little bit different than the previous panel. We've each prepared presentations that we'd like to go through, and we would like to reserve some time at the end for questions and hopefully some lively discussion as well. We heard a lot this morning with the first panel about some unflattering comparisons between the NCAA and fallen communist regimes and some other unkind words that were geared towards the NCAA. Unfortunately, the NCAA is not going to fare much better with at least two of our three speakers. That theme is going to continue here, starting out with a look at a case which Joe had alluded to, a case that was brought against the NCAA and was decided last year, which exposes certain archaic and unevolving attitudes which serve to marginalize individual sports under the guise of equity with respect to eligibility and amateurism at the collegiate level. This is the case of Jeremy Bloom versus the National Collegiate Athletic Association and the University of Colorado. And to begin looking at that case, we'll begin with a look at what it means to be an amateur. What is amateurism? In sports, an amateur is one who engages in athletic competition without material reward. Upper-class Englishmen in the 19th century used the concept to help define their social status, to describe anybody who competed in athletics without pay. By the beginning of the 20th century, leaders of two major sports movements, the American Intercollegiate System and the Olympic Games, had adopted the concept of amateurism, claiming that it developed competitors who were, quote, morally superior to professional athletes. If you didn't receive pay for your participation in sports, you were morally superior to those athletes who did. In the early 1900s, the concept of amateurism was so important that strict rules regarding it were in place for Olympic athletes. Under these rules, athletes who received prize money for athletic competition, athletes who were sports teachers, or athletes who had previously competed against professionals were not considered amateurs and were therefore not allowed to compete in the Olympics. In a well-known incident, Olympic officials stripped decathlete Jim Thorpe of 2 gold medals that he had won at the 1912 Games because it came to light that he had once accepted money to play semi-professional baseball. In 1974, after communist bloc nations had been subsidizing their athletes for decades, the Olympics ceded to athletes the right to compensation, and shortly thereafter permitted professionals in sports whose governing bodies did not object to their participation. As evidenced by the posthumous return of Jim Thorpe's medals in 1982, amateurism by the 1990s was a concept of diminished importance and one of more of a technical rather than a moral distinction that is except for the NCAA, as we'll come to see in the Bloom case. Today, the key to amateur sports is the question of eligibility. The question of eligibility is a decision of the athletic governing body of whether a particular athlete or a particular team can participate in any given sporting event or in a league. Establishing eligibility under a particular rule or a bylaw is the province of the applicable governing association. Eligibility rules cover all possible requirements and permutations regarding a potential athlete, and these can include the no pass, no play rules, no transfer rules, anti-marriage rules, summer camp rules, no agent rules, and rules regarding redshirting. The eligibility debate in the Jeremy Bloom case concerned an individual versus a team athlete, commercialism in the form of salaries and signing bonuses versus endorsements, and the artificial construct of amateur status as fashioned by the collegiate governing body, the National Collegiate Athletic Association, or the NCAA. The NCAA is a voluntary, unincorporated association that regulates intercollegiate amateur athletics among its more than 1,200 member institutions, which is comprised of colleges and universities. The NCAA was established in 1906, originally known as the Intercollegiate Athletic Association of the United States, becoming the NCAA as we know it today some 4 years later. The NCAA was originally established around the turn of the century in response to increasing concerns over the safety of football. At that time, safety gear, safety equipment was not used in football, and the 1905 football season, just prior to the formation of the NCAA, saw 18 deaths and 149 serious injuries to collegiate football players. The NCAA rules are established by representatives of member institutions, that is, the colleges and universities that comprise the NCAA. And these rules generally come about at the NCAA's annual convention. All NCAA legislation must be voted on and adopted by a vote of all of the active members. As a condition of membership, each institution is obligated to apply and enforce all of the NCAA legislation as related to its own athletic programs. Among other functions, the NCAA maintains, applies, and enforces the rules of eligibility and the standards of amateurism in connection with student participation in intercollegiate athletic events. The United States Supreme Court has recognized that the NCAA is the guardian of an important American tradition, namely amateurism in intercollegiate sports. The NCAA first addressed the issue of amateurism in its 1906 Constitution, shortly after the association's formation, making student eligibility to participate in intercollegiate sports contingent on the student athlete not having accepted at any time or received at any time money or other consideration for his or her athletic endeavors. By 1916, the NCAA specifically defined amateurism in its bylaws, stating that an amateur athlete is one who participates in competitive physical sports only for the pleasure and for the physical, mental, and moral and social benefits derived therefrom. The NCAA's current principle on amateurism states that student athletes shall be amateurs in intercollegiate sports, and their participation should be motivated primarily by education and by the physical, mental, and social benefits to be derived. Student participation in intercollegiate athletics is an avocation, according to the NCAA, and student athletes should be protected from exploitation by professional and commercial enterprises. I hear a few giggles at that statement by the NCAA. This principle of amateurism is reflected in the NCAA's stated basic purpose, which, according to the NCAA Constitution, is to maintain intercollegiate athletics as an integral part of the educational program and the athlete as an integral part of the student body, and by doing so, retain a clear line of demarcation between intercollegiate athletics and professional sports. Article 12 of the NCAA bylaws governs student-athlete eligibility with respect to amateurism. One of its bylaws states, in part, that only an amateur student-athlete is eligible for intercollegiate athletics participation in a particular sport. Bylaw 12 also establishes the numerous ways in which a student-athlete can lose his or her eligibility to participate. And the bylaw describes prohibited forms of payment to student-athletes. Among these is a prohibition against student-athletes granting the use of their name or likeness in connection with commercial products, even if the student-athlete is not compensated for this use, and even if the offense occurred prior to the student-athlete's collegiate enrollment. There is a carve-out for certain pre-enrollment offenses, provided that certain criteria which are established by the NCAA are met. Article 14 of the NCAA bylaws also addresses amateurism, stating that a student-athlete shall not be eligible for participation in an intercollegiate sport if that individual takes or has taken pay or has accepted the promise of pay in any form for participation in that sport, or if the individual has violated any of the rules codified in Bylaw 12. So these two articles of the NCAA bylaws, Articles 12 and 14, operate to prohibit a student-athlete from receiving pay for skill in his or her collegiate sport, as both articles have sections which refer to losing eligibility in an intercollegiate sport if that student-athlete also uses his skills for pay in that sport. If the collegiate sport and the sport for which pay are the same, then the eligibility will be lost. The amateurism rules regarding dual sport athletes were modified in the 1974 NCAA Convention. Juxtaposed with the eligibility requirements already discussed, since 1974, the NCAA has allowed student athletes to compete as professionals in one sport while retaining their amateur status in another sport. They'll allow this provided that the student athlete does not receive financial assistance from the member institution. This 1974 rule change is what enabled Drew Henson to play football for the University of Michigan while receiving a $2 million signing bonus from the New York Yankees, and allowed Chris Wenke to accept a $400,000 signing bonus from the Toronto Blue Jays just prior to winning the Heisman Trophy as quarterback at Florida State University. In order to compete on the collegiate level while attending a school which is a member of the NCAA, a student athlete must agree to abide by all of the NCAA's rules and regulations. However, under Article 14, the NCAA has discretion to provide a waiver, exempting individuals from the application of a specific NCAA regulation. It was such a waiver from the NCAA which Jeremy Bloom sought. At the age of 15, Jeremy Bloom was the nation's best freestyle mogul skier in his age group. Also at the age of 15, Bloom was the youngest member named to the U.S. freestyle ski team. Jeremy Bloom was a member of his state champion high school football team, a track star, a skiing star, and a high school athlete with a 3.4 GPA. Bloom was awarded a scholarship to play football for the University of Colorado in 2001. However, he deferred his admission to Colorado in order to train for the 2002 Winter Olympics, in which he placed 9th. That season, he became the youngest World Cup freestyle moguls champion in history. Skiers like Jeremy Bloom earn very little prize money. Instead, they generally rely on endorsements from corporate sponsors to finance the high cost of travel and training that comes with elite-level competition. Jeremy Bloom was no different, and he had a 6-figure endorsement income from Oakley, Under Armour, and from other companies to help pay for his coaching and training so that he can continue to compete at the top levels. Jeremy Bloom also had an exclusive modeling contract with Tommy Hilfiger. He had appeared in segments on television shows such as Extra and Access Hollywood and MTV, and he was offered a hosting position on Nickelodeon. This exposure to television and media seemed appropriate for Jeremy Bloom, since after competing in the Olympics, he did decide to pursue his education at the University of Colorado as a communications major. He also took advantage of the opportunity to play football at the University of Colorado, yet he declined his scholarship from there. Bloom played 2 seasons of football at Colorado as a kick returner and a wide receiver, and he was named first-team freshman All-American. At the end of each football season, Bloom would rejoin the World Cup circuit. Bloom, however, was concerned that his endorsements and media activities might interfere with his eligibility to compete in collegiate football. On Bloom's behalf, the University of Colorado first requested waivers of the NCAA, asking a waiver of the rule restricting student-athlete endorsement and media activities. And then the University of Colorado requested a favorable interpretation of the NCAA rule restricting media activities. The waiver request noted that mogul skiing, which was Bloom's other sport, was not a collegiate sport, and that endorsements and sponsorships were the standard form of compensation in professional skiing, much like salaries and signing bonuses are the standard in baseball. Bloom also contended that the opportunities that were presented to him pre-existed his status as a collegiate athlete. That is, he had these opportunities long before he ever set foot on the campus of the University of Colorado. The University of Colorado filed its initial waiver request in February of 2002. This waiver was denied by the NCAA. Bloom then brought suit against the NCAA, seeking an injunction which would allow him to play football for the University of Colorado while continuing at the same time to accept his skiing sponsorship money in order to support his professional skiing career, the pursuit of which professional career the NCAA rules permitted. In his complaint, Bloom alleged, among other arguments, that he was a third-party beneficiary to the contract between the NCAA and its member institutions, in his case, the University of Colorado, and as such, he was entitled to enforce the NCAA bylaws permitting him to engage in and receive compensation from a professional sport which was different than his amateur sport. Bloom also argued that, as applied to the facts of his case, the NCAA's restrictions on endorsements and media appearances were arbitrary and capricious. The trial court determined that Bloom was indeed a third-party beneficiary of the agreement between the NCAA and the University of Colorado. The trial court also determined that Bloom truly was an amateur in the sport of football. However, in spite of these determinations, the trial court held that Bloom was not entitled to injunctive relief because he could not satisfy all of the factors required for an injunction, including his falling short on the requirement requiring reasonable probability of success on the merits. Bloom appealed the trial court's decision. The appellate court first found that Bloom had standing by determining that because each student-athlete's eligibility to compete is determined by the NCAA, Bloom had standing to contest the meaning or applicability of NCAA eligibility restrictions. With respect to Bloom's claim of arbitrary and capricious action by the NCAA, the appellate court noted that courts are generally reluctant to intervene, except on the most limited grounds, in the internal affairs of voluntary associations, of which the NCAA is one. The court noted that Bloom does not have a constitutional right to engage in amateur intercollegiate athletics at the University of Colorado. Despite this reluctance, the appellate court noted that relief from our judicial system should be available if voluntary athletic associations act arbitrarily and capriciously towards student athletes. So the question then became, was the NCAA arbitrary and capricious in its handling of Bloom's situation? To answer this question, the appellate court turned to the NCAA bylaws. Bloom relied on the bylaw allowing an athlete who is a professional in one sport to represent a member institution in a different sport. Bloom asserted that because a professional is one who gets paid, a student athlete is entitled to earn whatever income is customary for his or her professional sport, which, in the case of professional skiers, primarily comes from endorsements and from paid media opportunities. The appellate court recognized that, like many others in individual professional sports, such as golf, tennis, and boxing, professional skiers do in fact obtain much of their income from sponsors. The court continued, however, that none of the NCAA's bylaws mention, much less explicitly establish, a student-athlete's right to receive a customary income for a sport. To the contrary, the appellate court noted, the NCAA bylaws prohibit every student-athlete from receiving money for advertisements and for endorsements. The appellate court found that the NCAA bylaws express a clear and unambiguous intent to prohibit student-athletes from engaging in endorsements and paid media activities without regard to when the opportunity for such activities originated, without regard to whether the opportunity arose or exists for reasons unrelated to participation in the amateur collegiate sport, and without regard to whether the income derived from the opportunity is customary for any particular professional sport. The court continued that the clear import of these bylaws is that although student athletes have the right to be professional athletes, they do not have the right to simultaneously engage in endorsement or paid media activities and to maintain their eligibility to participate in amateur competition. According to the court, this application of the endorsement and media appearance rules in Bloom's case was rationally related to the NCAA's legitimate purpose of retaining the, quote, clear line of demarcation between intercollegiate athletics and professional sports, end quote. Under these circumstances, the appellate court found no abuse of the trial court's discretion in failing to fault the NCAA for refusing to waive its rules to permit Bloom to pursue any television or film opportunities which came his way while he was a student athlete. The court concluded that it was not convinced that the NCAA treated Jeremy Bloom unfairly in the manner in which it denied the request to waive or to interpret its rules, and accordingly, the appellate court affirmed the trial court's order. On August 17, 2004, about a month after the appellate decision was released, the NCAA issued a press release in which it announced that its student-athlete reinstatement staff had determined that Jeremy Bloom had rendered himself permanently ineligible for intercollegiate athletics with multiple and willful violations of NCAA rules regarding endorsements. Bloom currently is the reigning World Cup champion in moguls freestyle skiing and is nearly a lock to make the Olympic team for the Turin Games in February 2006. Immediately after competing in the freestyle moguls in Turin, Bloom is planning to attend the NFL Combine, held the week after the Winter Games end, in hopes of landing a job as a punt returner and a receiver. He plans to travel directly from Turin to Indianapolis in order to attend the Combine. Toward this end, Jeremy Bloom recently signed an agent to, quote, get some of the politicking taken care of for him. Bloom's real offense, and what ultimately ended a promising collegiate football career, was the fact that he excelled in a non-traditional sport, in addition to his collegiate sport. If Bloom had been a dual-sport athlete in any other traditional team sport, in which athletes are paid a salary for their participation, his continued collegiate participation would have been a non-issue. Similarly, if he had been able to receive a traditional salary for his skiing, he likely would have been permitted to continue skiing professionally while retaining his collegiate eligibility to play football. Unfortunately for Bloom, though, his professional sport was an individual sport, with no feasible income source save his sponsor's endorsement money. The NCAA's decision was that in order for Bloom to maintain his eligibility for college football, he had to give up those endorsements and his other contracts that he had received through his reputation as a professional skier. Doing this would have undoubtedly harmed his skiing career in that his training would have suffered for lack of funds. The NCAA could have provided Bloom with a waiver. Under Article 12, a student athlete cannot receive payments for athletic skill in their collegiate sport. Under this rule, Bloom does not violate the NCAA bylaws by receiving money for skiing while playing collegiate football. The NCAA's amateurism rules are inconsistent with other eligibility rules which allow professional athletes to compete as student athletes, provided their professional and amateur sports are not the same. The blanket ban on endorsement money ignores the reality of many individual sports and many individual athletes, in that they will not have a team to pay them a salary, they're not going to receive a signing bonus, and they must rely on sponsorship dollars in order to compete in their sport. This includes standouts in skateboarding, snowboarding, motocross, and other individual and action sports. These athletes, as soon as they receive a sponsor's money to help defray training and competition expenses, are effectively precluded from being dual sport athletes in the eyes of the NCAA. The current NCAA rules and their application prohibit compensation due to athletics ability in general, instead of more narrowly circumscribing activities related to the student-athlete's collegiate sport. These non-mainstream individual sport athletes will do no more to undermine the stated goals and the purposes of the NCAA and its amateurism principles than would any dual sport athlete who gets paid for his services in the NFL or through the auspices of Major League Baseball. However, the short-sighted application of the NCAA rules by the NCAA and its refusal to bend serves to marginalize dual sport student athletes who participate in individual sports. And on that note,
well, I'm going to. That was outstanding. Let's give Lisa. I just personally can't take it anymore. Listening to that, and because we promised interactivity, and I don't mean just for 2 seconds. I would love sort of a little show of hands or any interactivity you might want to have on was that rightly or wrongly decided. Then we're going to move to golf and other Olympic sports. But anybody have any strong feelings about this? I sure do. Besides Lisa. Or otherwise we just take a show of hands. I mean, how many think Bloom was rightly decided? Anybody? Oh my, well.
You may not like the outcome, but I mean that was the stated, at least from what I understand, the stated rule that there's a ban on endorsements. I mean, it's one of those, it is what it is, but that was the rule. I mean, you may not like the result in this case, but I assume the reason why there's fear of endorsement money as opposed to a straight salary is because you can imagine a college booster trying to quote money as endorsements for maybe a more marginal athlete that isn't clearly getting that endorsement money because of a world-class skier. I mean, I assume that's the issue that the NCAA is concerned
well, and see, I take a different look at it. I assume that the NCAA is opposed to the individual athlete getting endorsement money because of its own pockets. That the NCAA, right now there's a rule which says that student athletes can't get any money for endorsements student athletes can't get any money for endorsements, but the member institution can, which is why you heard with Maurice Claret. His shirt was the best-selling shirt at Ohio State, but he doesn't see a penny of it. There's hundreds of thousands of dollars being made. Who's making it? Well, the member institutions in the NCAA. And if you allow a student athlete to do their own individual endorsement deals, is that going to take money from the NCAA? Likely.
But the NCAA, I think, looks at that as every university. There's no competitive disadvantage. And Maurice Claret will sell his jersey at Ohio State. Michigan State will sell their other players' jersey. But if you have boosters paying money under the table, I mean, that would be the unfair advantage, because I would assume not every school is going to try and bend rules and trying to avoid that essentially cheating. And maybe the question is that a problem? Is that an issue in terms of endorsement money sort of being like soft money that they just couldn't police on a case-by-case basis?
But I think if I could jump in here, part of the problem with the NCAA argument is that they allow a football player to play minor league baseball and collect money, and they don't let anybody get any money or even let anyone use their name or likeness. So they make a bright line distinction that's completely arbitrary. And if Alan was here, he'd bash them for that because that's part of their hypocritical system. So I think when they make that decision, they open themselves up for the argument that, what did Jeremy Bloom do wrong? He just chose to participate in two different sports. One sport is traditionally endorsement-based and sort of off-the-court income. The other sport is football. Why can't he participate in NCAA football and participate in mogul skiing and collect all the benefits that you get as a mogul skier? And the other thing about mogul skiing is that you need to travel and you need to train, and that all costs money. Well, who's going to pay for that? There's no University of Colorado mogul skiing team. So they leave him out there hanging because he has these two talents. But your point is well taken. It's a money grab. If Jeremy Bloom can get endorsements, a marketer who's interested in the Colorado football program, right now they have one choice, and that is to pay the University of Colorado. if they want to get some signage in the stadium, if they want to participate and get any part of the goodwill of Colorado football, you got to pay the University of Colorado. If they could do a deal with Jeremy Bloom, they'd get a piece of the action and cut out University of Colorado. So from the NCAA's perspective, where do you, first of all, why would you want to give away any of the money you're making right now, and then where do you draw the line, where do you stop?
Maybe strict constructionists who feel like, hey, a deal's a deal, a rule's a rule, and he waived his right by doing what he did because he knew what the rule was when he did what he did.
Well, I would just say to say that it's a money grab by the NCAA. The NCAA allows a player to be paid to play baseball, let's say, by a minor league team, and in that instance, the money's not going to the NCAA. So it's different. So all of their rules aren't oriented to take the money that would otherwise go to the player to the institution, to the member institution. It sounds like that they differentiate between a salary for performance and pay for to be a model as something a little more nebulous that they may not be able to control. And now you have a lot of corporate influences instead of pretty defined sports entities that would pay for performance. You may now have a Colorado booster who owns a local clothing store, and he's going to pay Jeremy Bloom for being a model, when in fact it's really for being a player on the football team.
Right, and from a practical perspective, it is completely nebulous. How would you control it? How would you govern it? But I think the problem is when you look at the way they handle a football player who's also a minor league baseball player, I think they open themselves up to the Allen argument that this is part of the cartel. Because if Chris Wenke can play minor league baseball, maybe he'll just go play minor league baseball, but he'll never come play NCAA football and win a Heisman Trophy. So the NCAA may never get the opportunity to make money off of Chris Wenke because he might just go take money, play baseball, and then go to college with a fat wallet. So I think the way those rules apply, they're kind of protecting their own.
Anyone persuaded now want to vote that Bloom was rightly decided? We're still down to those two. All right, you win the case.
We didn't lose anybody.
Let's move on. Get even.
Well, my discussion is really kind of turning the corner from amateur status to pro. Once they decide, okay, I'm definitely going pro, what does it take to qualify to be a member of the LPGA Tour and compete week in and week out? Just kind of a brief show of hands. Is anybody familiar with how you get on the LPGA Tour or golf? Or I don't want to talk about it. Okay, well, you guys already know. All right, so in order to be eligible to compete week in and week out on the LPGA Tour and to have your membership and hold your tour card, you have to compete in qualifying school. We call it Q School for short. And in order to be eligible to compete in qualifying school, to earn your tour exempt card, you have to be, among other things, at least 18 years old and a female, and that's female from birth. So you see where this is going. We have two major issues that really come up with folks with respect to eligibility on the LPGA Tour, and that's age and gender. In special circumstances, females between the ages of 15 and 18 years old may be eligible to qualify for the LPGA Tour by satisfactorily demonstrating to the commissioner that they have the capacity to assume both the professional and the financial responsibilities required to be a tour member. We're going to start with the age eligibility discussion, and I know Alan and Joe got into this a little bit before, so we're going to cruise right through this and then get on to some of the meaty stuff in gender. Common arguments against age restriction that we hear are, number one, if females can compete, if younger females can compete, why not let them? The LPGA shouldn't bar them exploiting their own talent. Two, it sounds like an antitrust issue because the LPGA is saying absolutely no. You can't compete on our tour anyway. Or in three, the third major argument is age restriction should be illegal, because we're preventing folks from making a living, right? Aren't there laws against that? Somewhere in the U.S. at least. First, let's go through the practical implications of young people, or really children, when you're talking about between 15 and 18 years old competing on tour. Since you all aren't familiar with how we're constructed, our composition is actually a little bit different than some of the other leagues in that their folks are actually employees. All the members of the LPGA Tour are actually independent contractors. So what that means in the very real sense is they really chart their own course. That means they make their own hotel arrangements, their flight arrangements. They lug those clubs from course to course. They figure out how to get there and how to pay for their presence on tour in order to even tee it up. They do all that and face those challenges before they even tee it up the first day to see if they can qualify for the tournament. After that point, they do compete day in and day out with usually 144 other women in a full field event to see where they kind of rank out in that. In addition to kind of some of the other pro-am, everybody know what pro-am is? Played in one? Okay. Into some of the other pro-am obligations and social obligations, interactions with sponsors. You got to kind of wine and dine them a little bit. That can be a lot of pressure. And then you add in kind of the media scrutiny. So really what it means is you got to have someone out there that is, one, mature, able to handle kind of these pressures day in and day out, and able to handle themselves traveling in the capacity that they do, and two, can handle the performance pressure of really competing week to week, because that's really what it means for us, at least, from the end of February into November. So those are the practical implications, and we have found through some very limited exemptions that have been special circumstances whereby young folks or young children have been allowed to compete on tour, there is a greater or more likely instance of injury and then premature retirement or just simply mental stress. We have had a couple of folks, really, one woman who competed in the 80s who was 12 originally, before these eligibility rules were actually enacted, who suffered some significant mental strain and is still kind of struggling with those today. So we take it pretty seriously in evaluating on a case-by-case basis whether they can just simply handle it. Okay, let's circle back. What's the legal basis for this? And we all have talked about the practical implications. And if you don't agree, feel free to, say, I don't agree with that. But the legal basis is, for those of us whose sun doesn't rise and set on antitrust law, let me review a little bit. The Sherman Act, of course, prohibits concerted refusals to deal or other combinations to restrain trade. We at the LPGA like to think that we're single entities whose actions don't necessarily trigger an antitrust issue, one, because our folks are independent contractors. But if it does, and the LPGA and LPGA Tour members are deemed somehow to be separate actors colluding together to keep these young children from making a living, we still think that the eligibility restriction will be a pretty viable rule. It's going to be evaluated under the rule of reason analysis. And really what that means is, do the pro-competitive effects outweigh the anti-competitive effects of restriction? And then we're talking about that three-part burden-shifting test, in that the plaintiff must prove that the age restriction has an adverse effect on competition. Once they do that, that's pretty easy. The defendant must prove that the anti-competitive effects outweigh the adverse effect, and then if they do that, the plaintiff must then prove that the legitimate objectives could be achieved by less restrictive means. So when we turn this around and really kind of, when the rubber meets the road, the analysis here is that the restriction is there to protect the sport and the competition by evaluating the ability of children, really, to compete in competition in the framework of how our competitions are conducted. And then the second part of that is that the rule really is a flexible one, and it tries to be no more restrictive than necessary by rather evaluating people on a case-by-case basis, rather than kind of this bright line, no one under the age of 18 can compete. And by the way, that analysis is done by the commissioner herself now, rather than any of the players. The players actually don't have any say in the future, or lack thereof, of any child star or phenom's ability to compete in Q school to earn their card. From an employment law perspective, obviously these are state laws we would be talking about. It's really kind of a similar analysis, and it relates to the restriction to actual capabilities of the athlete to perform the job meaningfully and to play and earn money based on the association's experience and the objectives set forth by the LPGA Constitution. So that's kind of a rundown on what our age restrictions are and why they're there, and really what the practical meaning of them are. So the second part of eligibility for the LPGA comes down to gender. And I know everyone's heard something about this, right? Annika, last year to be
Can
in.
we just stop there?
Okay, let's stop.
Okay, just show of hands again. Does the LPGA have it just right? I mean, out of everything we've heard all day so far, this is about as good as it's going to get. Does anybody, Gary, or anybody else, want to say, no, that's not right, or Fallon, where he really say, oh, come on, 12-year-olds who can play should play. Worry about all that other stuff later. Or everybody sort of in favor of the LPGA rule? Gary?
Yeah, certainly they do have a right to allow these exceptions, and plus they're not employees, they're independent contractors.
Okay, you win this one.
Okay,
Sure.
that's good. So none of you will be actually suing us, so that's a great thing, because it actually hasn't been challenged. We're just.
Shall we go to the qualifying school?
Can you go to qualifying school?
Shall we go to the qualifying?
No, she actually did not. She has not applied to be a member of the LPGA at this point. She plays in some of our events under a tour exemption, and basically what that is each tournament sponsor has the ability to invite either an amateur or a professional who is not a tour member to compete in their tournament, subject to a few qualifications. You have to have a ridiculous handicap, like 3 or 4. It's ridiculous to me because mine's a zillion. But yeah, so that's how she competes on our tours. But she is not a member at this point. So.
She can, now that she's chosen to be professional, she can accept prizes.
Absolutely. Under the USGA. As an amateur, she couldn't under the USGA rules, similar to NCAA. But
Isn't it true that when she, let's say she could have at any time given up her amateur status before she did and accepted prize money?
absolutely. I don't know that there's an age limit on amateur status when you can turn pro. I think it's once you make that decision, really, what are your opportunities at that point? You don't have an opportunity to play on our tour, subject to those special circumstances and that waiver before 18.
So she's never applied for a waiver?
No, to date, no. She hasn't applied to compete in qualifying school to be an LPGA member. But also keep in mind that she's still trying to pretty actively qualify to play on the PGA Tour. In some of their events. And I think that maybe, I haven't talked to their folks or anything like that, so this is no inside scoop, but just kind of conventional wisdom would say, because we have conflicting event policies with respect to our tour members, it may make sense to some degree for her to not be a member if she's still actively trying to participate in PGA Tour events, because obviously those events go head up against some of our events. Mostly all of our events. Okay. Well, we'll keep moving. So the second piece of the eligibility issue with respect to the LPGA is gender. And like I said before, I'm sure it's a fleeting memory, I'm sure by now, but about a year and a half ago now, Annika participated or tried to qualify for a PGA Tour event. And almost in the very next breath of that, and almost every television show I saw was, well, if Annika can compete with the men, why can't the men compete with the women? Because our rule says you can't. No, men are obviously not eligible. You have to be female at birth, and we're going to address that at birth. So we're going to just talk about the female part right now. And the common arguments are, you're discriminating against men. It's a Title VII violation because you're excluding people from membership based specifically on gender. Okay. We're going to go through the practical implications again, because I think this is important to make sure we understand why the legal context is there. But the practical implications, really, of men competing on tour is that there's simply physiological differences we can't overcome that exist between men and women. And that means that men have more muscle mass than women. So if you're dealing with a man of the same height and weight as a woman, they have a strength advantage over the woman. And so in terms of golf, that means they're driving the ball further. So the impact on the LPGA Tour specifically and on golf in general as a competition is that lesser skilled men would dominate because of the unfair strength advantage, and men and women wouldn't be fairly matched in the competition, and that it would be easier for men to win the purses on the LPGA Tour versus winning purses on the men's tour. The result of that is that, or the result would be that there would be few, if any, female professional golfers around. Okay, so we understand the context. So what's the legal basis for actually having that female-only requirement. Legal basis is a couple of things. It hasn't directly been challenged, but in the legislative history of Title VII, as well as in an Eighth Circuit Court of Appeals opinion, although dicta, they recognize a bona fide occupational qualification exception to Title VII in that there are some things that you simply cannot overcome because of physiological constructs that would justifiably allow the restriction or the discrimination of a particular gender in this particular case. The second issue would be there is a separate but equal principle recognized in sports, not necessarily in the allocation of the dollars, which is the discussion we normally hear when you're talking about how much money is a college putting toward men's sports versus women's sports, but really in the sense of whether men and women compete together in team sports. That's where that whole separate but equal concept is recognized. And here, it's not discriminatory when it's due to gender because it arises from objective physiological abilities of the athletes themselves. Okay, so we're going to circle back to the at birth part. Being a woman from birth is also a requirement from the LPGA. Transgender issues. Has anyone heard very much about that in sports? And be honest. Pardon? Renee Richards. Yes. We also have an example of that in golf. Her name is Meanne Bagger, who is currently playing on the Ladies European Tour. And we're going to specifically talk about men going through sex changes to become women and then trying to compete in a professional framework for golf. At this point, the IOC, the LET, Ladies European Tour, and currently the USGA have all changed their rules such that they allow participation by a woman who used to be a man and who has also undergone 2 years of hormone therapy to compete in professional sports in their context. We have not yet changed that rule. The current argument is that competitive advantage, a man's competitive advantage is decreased when they become a woman and go through the hormone therapy because the estrogen kind of really balances out the testosterone and the androgen hormone. It's all very complicated. All I know is they say that the hormone therapy is supposed to equalize everything. Meanne Bagger, who is currently participating on the LET Tour, petitioned our former past commissioner, Ty Votah, on a few different occasions to kind of spur change on the LPGA's, with the LPGA's policy because she was very, very interested in coming to compete over here. That has not happened at this point. The practical implications, we're just really not clear. What they would be. I mean, theoretically, you're probably talking about a very, very small group of folks. One, you're talking about out of like the entire universe of golfers, how many are actually good enough to compete at a professional level? And from that small percentage, how many would actually go through a sex change and still want to compete on a professional level? So, I mean, you're probably talking about a very small number, but we just don't have any clear guidelines to that yet. From a legal standpoint, U.S. laws simply have not progressed along or is not as fully developed as European laws in protecting the rights of transsexuals. So, from the federal standpoint, there are currently no laws. Transsexuals have no protection under specific federal legislation. On the state, county, and municipal level, we found that only one state, the state of Illinois, will have a law coming into effect in 2006, January in 2006, and approximately 30 counties and municipalities have statutes and or ordinances prohibiting discrimination on the basis of sexual orientation and or gender identity and expression. So what that means is, yes, there are some things out there, but most of them limit the protection of transsexuals to contexts such as employment, housing, and education, and in some cases, places of public accommodation, but not necessarily rights to compete or against specific laws or rules stating that excluding competition. So that's what's dicey in eligibility at the LPGA.
Does he carry the day again? We have to ask everybody thinks they got it right in the gender area as well. Everybody thinks they didn't get it right. I think you guys are super too, I think. Unanimous
I don't know, that's just what they
approval of the
have one.
That's 2 and
Or everybody's just coming down off their caffeine fix. No, I said everybody's just coming down off their caffeine fix.
Oh, yeah, right.
That's what it is.
Okay. Well, I'd like to turn the discussion back to the Jeremy Bloom type issues. And in light of the Bloom case, this is going to come up again and again. Did I do something to put that little menu on there? Can I get rid of that or no?
Just use the mouse. Touch the screen with the mouse.
Okay. Jeremy Bloom, as you've heard before, was a mogul skier and a football player. And I think not only was he a perfect candidate to change the rules that he was unsuccessful in changing, but he's part of a growing trend. And I start with this question, and if Alan were still here, he would say, it is never too early, and we all know it is never too early. And I've given you 3 examples here. You probably all recognize Maria Sharapova. And when you're dealing with an athlete like Maria Sharapova, her concern is not NCAA eligibility. If she decides she wants to go to college one day, she can do so well-funded. The Jeremy Blooms of the world, however, are just beginning. This is just the tip of the iceberg. And the 2 other gentlemen who are on that slide, the middle fellow is Luke Matrani. He's the youngest member of the United States snowboarding team. He first turned pro around the age of 12. The fellow next to him got a head start at the age of 7. Michi Brusco, he's a skateboarder. Both of these guys get paid to participate in these sports. And these sports are growing year by year. New sports emerge, and they get younger and younger. Not only the athletes that participate in them, but the companies that market them and the companies that get involved, they want to project a younger and younger image. The other side of this trend is it tends not to be football, baseball, and basketball. So these athletes more and more will present Jeremy Bloom-type problems. They either had some commercial activity in a non-traditional sport, but yet are qualified to play in a collegiate or high school traditional sport. And the real risk here is when you're advising these people or representing them is that there are many potential pitfalls for inadvertently jeopardizing NCAA and high school eligibility. There's a big scale between Maria Sharapova's endorsement income and the typical skateboarder, snowboarder, kiteboarder, or what have you. The value of an NCAA scholarship far outweighs the opportunities they have. So with the way the rules are, and as they were interpreted in the Bloom case was incredibly strict. They basically said, because it's so difficult and so nebulous to figure out what a person's getting paid for, they really can't go down that road. So what I'd like to do is just quickly walk you through the rules. You've already heard some of them, and show you some of the typical situations that can occur with athletes in these sports, and how they can innocently and inadvertently get themselves in trouble and jeopardize their eligibility both in college and in high school. The principal rule at work is Bylaw 12 you've heard about before, and this is the same rule that makes the distinction between salary income and endorsement income. This Bylaw 12.1.2 is the rule that allows an athlete to play college football and minor league baseball is the most common example. And this system is in place for the reasons that the NCAA deems it to be valuable. It's not going to change, so this is always here. Bloom tried to make the argument that why do you treat these guys differently? It wasn't successful. So this isn't going to change the reality of the NCAA's policy on advertising income and endorsement income. There's an absolute ban. You can't get paid for selling your name or likeness to anyone for any purpose. The other important thing to remember is that you can't permit anyone to use your name or likeness. So getting paid isn't the critical factor. If you permit someone to use your name or likeness, you've jeopardized your college eligibility. The other rule that's at work is called the athletics reputation rule. This also was part of the problem that Jeremy Bloom ran into. You can't accept any kind of pay or benefit for your athletic reputation. Jeremy Bloom was a very strictly interpreted case. It's a real warning sign. And this gentleman, Aaron Adair, is an example of someone who innocently and inadvertently jeopardized his eligibility. And I'll tell you his story. I want to see if you two guys still think These rules are fair, so let's have at it. Aaron Adair, he's public enemy number one under these NCAA rules. He was a high school baseball player in Texas with a promise. He certainly was on the track to have a college scholarship, maybe even a professional career. In high school, he suffered a brain tumor. He had a successful surgery and recovered. And after a long rehab and a long comeback, he got himself back into a baseball career where he accepted a scholarship at the University of Oklahoma. Competed on the baseball team and lost his father to leukemia. He wrote a book about his life story, how he recovered from cancer and losing his father. He did this while he was at Oklahoma and while he was playing baseball. This is his book. It's a biography and a motivational story. When he began to promote it, or at least publicize that he had written a book, the athletic department told him, "Hey, wait, you can't do that. That's commercial activity." And Aaron Adair said, "What do you mean it's commercial activity? It's my story. Why can't I tell my story? I wrote a book, and it has nothing to do with my athletic ability or reputation. It's about surviving cancer and losing my father." Well, the NCAA said, no, it's a commercial activity because the book is something that you can purchase. It's for sale, so it's commercial activity. He inadvertently jeopardized his NCAA eligibility. What do you guys think?
The facts are sad, but I guess the concern would be sort of this slippery slope. I mean, if we've got the kids being targeted earlier and earlier in a particular school, and there's sort of a sham transaction of wink, wink, nod, nod, Booster is going to pay you to write a book. And like I say, maybe it's just a sham transaction that's essentially just a way to influence the kid to go to, say, Ohio State. Writes a book, doesn't sell copy one, but he gets a $500,000 advance. More likely to go to Ohio State than someplace else. I mean, these facts are not that, but I assume that's the concern is the going down that slippery slope of recruiting violations. That'd be my guess.
I think you're right. I think where do you stop is the problem from the NCAA's perspective. And if you're in Allen's camp, the whole thing is artificial. This is just another manifestation of its artificial nature. And I think in a lot of these issues, they just choose not to get their hands dirty with it because it's really tough, and it would be a case-by-case basis, and there would be more exceptions to the rule than there would be rules.
Well, I think that's the point is when you've got how many Division I universities and how many different sports and how many. If you took everyone by case basis, it'd be this is to bog down something along the lines of
right.
I don't know, welfare.
Right. Right, and if you have the privilege to read the NCAA bylaws, it's like the tax code. It's about that thick. And yeah, you're right. I think that's part of the problem. It's a system. It has its rules. You can debate whether they're right or wrong, whether they're fair or unfair, but they exist and they have consequences. So I think in this arena, what you have to be really cognizant of, especially when you're advising families and kids who are in the system, that they have to be very conservative in their judgments because you're up against an entity that makes its own rules and interprets its own rules. And the courts, by and large, give them leniency and let them don't really disturb their decisions. So you have to be aware that you're making a decision at the age of 10 or 12 that's going to have potential consequences 5 or 6 years down the road that might be not what you like to, not the consequences you want to endure.
I guess the only thing that might persuade me is if the code's that big, are you in jeopardy of ruining your status by hiring a lawyer to tell you, when you can?
It's a good question.
Yeah.
It's a close line. There's hiring an agent for anything is going to make you ineligible unless your agreement with the agent is related to a specific sport. So the guys that go through that system where they play football, college, and baseball, their agreements with their agent will be strictly to baseball. If you just sign an agreement with an agent that doesn't limit itself to any sport, then you've made yourself ineligible for any sport. You can get advice from a lawyer. And you can even get advice from a lawyer about a prospective contract with a major sports team. That's acceptable so long as that lawyer doesn't represent you at the end of the day when you sign that contract. So the laws are fuzzy, and I'm not sure everyone plays by all those rules, but they're out there. Sure.
My grandmother used to have a saying that every tub must rest on its own bottom. I can't see, you have to excuse me, in this situation, where this person, where there can't be some modification based on the circumstance of this one individual case.
You talking about Aaron Adair's case?
Yeah.
Well, I agree with you. I agree with you. And people have succeeded. There's one example at the end that I'll tell you about involving the performing arts. But you're right. In Aaron Adair's case, the rule is completely unfair and unreasonable. But there, the NCAA takes a very strict interpretation of what you get because of your athletics ability. And they basically say, if you're an athlete, then anything that you're involved in, you can't say has nothing to do with your athletic ability. So in his case, yeah, I agree with you. It's
a man with a brain injury, how much competing is he going to be able to do?
Right.
I mean, common sense dictates that.
Right. He's on the team and he's wearing the Oklahoma uniform, so they say he's part of our system, and they drop the hammer. And they just don't show a willingness to get involved in the details on a case-by-case basis. In his case, I think you're right. It's unfair. But, and I guess the underlying point of all of this is that you have to be very careful when people are presented with opportunities or get involved in different commercial ventures. A pitfall that I've seen many, many, many times is with Olympic athletes. 99% of Olympic athletes may be presented with a commercial opportunity or two, but nothing on par with an NCAA scholarship. However, most Olympic athletes don't understand or appreciate the process they're about to get themselves into. If you take the women's ice hockey team, for example, in 1998 it was the first time women's ice hockey was in the Winter Olympics. Most of the women on that team were NCAA athletes. They were in college playing hockey. And most of the women on that team were not marketable in the true sense and knew that, and all they cared about was making that team and going to the Olympics and being part of the first ever women's Olympic ice hockey team. That's the typical scenario for most Olympians. They're so excited to be on an Olympic team, they will do whatever it takes to preserve that opportunity. Well, the first thing they'll be presented with is a marketing agreement from the national governing body, USA Hockey, US Soccer, what have you. And every one of those agreements will contain language conveying group likeness rights, meaning the team has the right to use images of 3 or more players on the team. Going back to those bylaws, even if you're not paid, that's still a technical violation of those bylaws. So here's an example in '98 of the women's team after they won the gold medal, and this is when you really make it big, you go to Disney World and you are on the cover of the Wheaties box, and here's their moment on the cover of the Wheaties box, but minus 5 players. There were 5 players on that team that were still in college and maintained their eligibility, so they're missing. There are 3 players in that picture who were college athletes but decided to pursue whatever commercial opportunities were available, so they're on that box. The story behind the story here is that no one in this photograph got paid for being in that photograph. General Mills was a USA Hockey team sponsor, so they got the right to take that photograph because they were a team sponsor. None of those athletes made any money. So you have 5 women who were on that team, went to every practice, played in every game, and they're not on that box, but their teammates are. With an example like General Mills, they're a sophisticated marketer, and they sort of foresaw that, hey, we're in an unusual situation where we've got a certain number of players here that are NCAA eligible. That doesn't always happen, especially when you get to the more fringe sports like skateboarding and snowboarding. You have less sophisticated marketers, and one of the real problems you can get yourself into is someone using a kid's name or likeness without even the kid's permission. The problem that creates, in addition to the fact that someone's just used your name and likeness and not even asked you for permission, much less paid you, is that the NCAA rules require and obligate the student and the school to take action to stop the usage. It happens a lot. It happened last year in the Frozen Four with Easton, a hockey equipment company, issued a press release talking about the fact that one of the players used their equipment, and the school and the student stopped that. But if they hadn't, his eligibility would have been at issue. I'd like next to show you an example of a situation I was involved in, and I'll start with the hypothetical, and you can see what you think. I got a phone call from a woman in Connecticut who her son was in the 8th grade, and he was an athlete, not a star athlete by any stretch. He played football and basketball. He mostly played because he enjoyed hanging out with his friends and playing sports, which is the first parent I've ever talked to in my professional career that described their child's athletics career in that manner. But be that as it may, the kid is in the gym messing around with his friends, and on the other end of the gym is a director for Gatorade, and he's casting for an advertisement. He's looking for a typical teenage kid. And so there are, on one side of the gym are all these kids with their overbearing parents waiting to get discovered for this ad. And on the other end of the gym is this kid with his friends messing around. So after the director sees 50 or 100 kids hoping to be the next Olsen twins, he looks over at this kid and says, that kid, he's got a look. I want that kid. You're going to be an ad. You're going to be an ad with Derek Jeter, Yao Ming. You're going to get paid a Screen Actors Guild minimum wage, and we want you to do it. And here's the agreement we want you to sign. And in the agreement, it said the two questions that the mother asked me, and I think she was pretty smart to do so, was to say, first of all, if he does this, is it going to affect his ability to play high school sports if he gets there and if he has the opportunity, and then if he gets to college, and if he has the opportunity to play college sports. And secondly, what is this language in the contract about? We have to indemnify Gatorade for any eligibility implications of doing this ad. So let me show you the ad, and we'll walk through the analysis.
Can Jimmy play?
Hi, Al. Jimmy?
Oops.
Jimmy, come play? Hi, Derek. Jimmy?
Can Jimmy play?
Jimmy? Salt Wright, Texas, 2212.
Whoa. It's my job.
Hi, Jason.
Can Jimmy play?
Jimmy! See you, Al.
Where am I going?
Hey, Jimmy! Can you play?
Vince Carter! Dinner! Jason! Lisa Nestle!
Jimmy, can you play?
Who's out there?
Pretty good. So this kid's in 8th grade. Can he play high school and college sports after doing that? Show of hands. He can. He's done. Why? What did he do? What has he done wrong? He got paid, but he got paid no more than the typical actor would get for that ad. First of all, he's in 8th grade, too. He hasn't gotten to high school or college.
It doesn't look like it's a parody. Does that make a difference? Like it's clearly traumatizing the event in a way that's trying to elicit laughs.
Right.
It seems qualitatively different than...
Right. Well, let's look at the rules that would apply. First thing is that what you do before you get to the NCAA can still be used against you and will be used against you. So the fact that he's an 8th grader doesn't get us off the hook. And there is a bylaw that attempts to address child actors is really what its purpose is. And it says that you can continue activity that you've done before entering college, but there are conditions, all of which must apply. So the analysis comes back to something similar to the analysis of a college athlete involved in a commercial activity, and these 5 factors have to all be met. The ones that concerned us in this situation were, first one was, is he involved in this commercial independent of his athletic ability? So in the case of a kid who has an ad for cereal, he's going to be okay. But this kid was picked. The director would testify that he was picked because of his look. But he does throw a baseball. He does dunk on Yao Ming. So we had some concerns about that. And then subpart D, he does not endorse the commercial product. The ad begins with him drinking the Gatorade. He's got the Gatorade in him, as Gatorade wants everyone to have, and he has this superhuman ability to dunk on people like Yao Ming. So these are the considerations, and this is the kind of analysis you have to go through to decide whether it's going to have an effect on you. But in light of the Bloom case, you have to think to yourself, this is going to affect me down the road. I can't control how they're going to decide it, and I'm dealing with an entity that's going to make up the rules as they see fit, and my rights to appeal to anybody are kind of limited. So to your question about whether it's a parody or not, I guess it would be case specific, and it would come down to this stuff. Is he endorsing a commercial product? The themes you see throughout these rules are being identified by name and image. So he's not identified, and he's not in there because he was the LeBron James of high school basketball. Whether you're endorsing something and whether it's because of your ability. So I guess it would depend on the ad if it was parody. I guess it would be completely not because of your athletic ability if it was the right kind of parody. But just to sum up there, what can these athletes that are on Olympic teams or in these sports, what can they participate? What kind of commercial activities can they be a part of? And one common exception is charitable activities. And like the last rule that I showed you, there are 9 conditions that have to be met to keep yourself out of trouble on this rule. And I suggest to you that when you run up against an NCAA bylaw that has 9 conditions, all of which must be met, you have to tread lightly, especially when Aaron Adair can't publish a book and Jeremy Bloom can't ski. So Aaron Adair was public enemy number 1. This is public enemy number 2, a client of mine, A.J. Malesko, who was on that 98 women's Olympic ice hockey team. She was not on the Wheaties box because she was at Harvard at the time. But here she is that summer on the cover of the Yellow Pages for Nantucket, where she lives, with some Special Olympians. Now, show of hands, if the NCAA won't stop these people, who will? Because certainly this is these people must be stopped, I think. Right. Yeah, do you two guys want to stop them or not? So here's the deal. This happened because I'm showing it to you, so obviously she got away with it. But it wasn't easy, and initially the NCAA said, no, this is commercial activity. And it's commercial activity because it's the Yellow Pages, and even though the Yellow Pages are free and handed out, the Yellow Pages are filled with ads. So she can't do it. What it took, she's not paid. And it goes back to the charitable exceptions. You got to get written approval from everybody. You can't miss class. You can't get paid. I think you could get your expenses paid in the right circumstance. And you can't endorse or promote anything. So here you notice her name is nowhere on this. It took lobbying from, it's insane. In New England, there's he was in the running to be the president of the USOC, but a USOC bigwig, writing letter after letter in the Harvard Compliance Department, lobbying heavily to get this allowed. Just one last exception. Has anybody seen this movie? You can't really see it. It's a little blurry. The 18th Angel, highly recommended. It's another exception. Darnell Autry was a running back at Northwestern and also a theater major. A director of this movie saw Darnell being interviewed and thought he had a lot of poise and offered him a part in the movie. And he was going to be paid just his expenses to go to Italy to shoot the film. It was going to happen in the summer. He wasn't going to miss class, and he was a theater major. NCAA said, no way, it's commercial activity. Autry succeeded where Bloom failed. He got a judge in Illinois to stop the NCAA, and the beauty of Autry's argument, and Bloom tried to make a similar argument but wasn't as successful. Autry said, hey, look, we're student athletes, right? I'm a theater major. I'm at Northwestern in a really renowned theater program. Here's an opportunity for me to act. If I'm really a student athlete, just because I play football, why can't I do this? So as a result of Darnell Autry, there is a specific exclusion, and it's got to be a student athlete seeking a degree in the performing arts. So you have to declare your interest right away. So when the NCAA loses, they still keep it tight.
Brain tumor doesn't work with performing arts, it does.
No, right. Right. I guess he would have had to be like pre-med. The other, it's interesting. I wonder what his major was. I should go look. And there's a sort of a sister exemption for being involved in a music video. And then I had to fit LeBron into this presentation somehow, being here in Cleveland. When you're dealing with these folks, if you also have to realize that there are high school rules. Every state has its own rules, so there's 50 different sets of rules. They largely follow the NCAA rules. But if you have a kid like Jimmy from Gatorade, we knew that if he did that ad and he then went out and played basketball the next week and scored on somebody's kid, that parent would be complaining that, hey, that's the kid from the Gatorade ad. He's ineligible. So when you have a kid of the right age, you have to be concerned not only about future NCAA eligibility issues, but also high school implications.
Chris, we can't thank you enough. It's a great presentation. Outstanding. We're going to take a 1-hour break. We'll be back at 1:15 for our guest speakers, but these panels will be available for individual questions for anybody who wants to ask an individual question. Thank you very much.